Welcome to the deep dive. Today we're tackling something pretty technical but absolutely vital in patent law. We're talking about means plus function claims.
Right. That's 35 USC 112 valve for anyone keeping score at home.
Exactly. It's all about how you define an invention when you describe a part by what it does its function, instead of, listing every single possible structure.
And it's tricky territory. A lot of patent claims can really succeed or fail based on how this is handled. Claiming functionally sounds broad, maybe even easy.
Yeah, like a shortcut.
Kind of, but it comes with really specific rules about how that claim gets interpreted. So our mission today is basically to unpack those rules. How do examiners, how do courts figure out if a claim is a means plus function limitation?
And what does that actually mean for how broad the claim is?
Precisely. And maybe most importantly, what do you need to know? If you're inventing or reading patents, what absolutely has to be in that patent description to back up these kinds of claims?
Because it really matters, doesn't it? Whether you're writing the patent or maybe trying to design around someone else's patent.
Or just curious.
Or just curious, yeah. Understanding 112 is fundamental to knowing the actual legal boundaries of an invention. Let's think about it like this. You're an inventor, brilliant idea, new gadget.
Right.
Maybe one part does something crucial. Now, you could try and list every single gear, wire, line of code, whatever it is.
Which would be impossible or just incredibly tedious.
Or you could try to claim it more simply by its function,
Wait.
like a means for doing X.
And that's where 112F steps in.
Mm-hmm.
It gives you a way to claim an element, and that's key. An element within a combination by its function, usually using that classic phrase, means for performing some function.
But there's a catch, right? The interpretation.
Huge catch. It comes from a case called In re Donaldson. See, normally the Patent Office gives claims the broadest reasonable interpretation, the BRI.
Okay.
But for a claim limitation that falls under 1 and 12, that BRI gets narrowed down a lot.
Narrowed down. What's the limit?
It's limited to only the specific structure, material, or acts that you actually disclosed in your patent specification as doing that job, plus, equivalence to that structure.
Okay. So it's not any way to do the function. It's tied directly back to what you actually showed and described in the patent document itself.
Exactly. So claiming functionally seems broad, but the rule actually ties it tightly to your disclosure. It's kind of a trade-off.
That's a really interesting tension. Broad language, narrow interpretation based on the spec.
It is the central trade-off, the quid pro quo, they call it.
Yeah.
You get to use functional language, which is convenient, but in return, you must clearly show the structure in the specification, and your claim scope is locked to that structure and its equivalents.
And the courts have said it's all about the words in the claim, not what you intended.
Absolutely. Doesn't matter what you meant to do or what you say elsewhere. It's the claim language itself that determines if 112F applies. Precision is key.
Okay, so the words matter immensely, which leads us to, how do we even know if a claim element is invoking 112F? You mentioned presumptions.
Right. There are two main starting points. First one's pretty straightforward. If the claim uses the magic word means or step for process claims and links it to a function.
Like means for converting.
Exactly. That creates a presumption that, yes, you're invoking 112F.
Presumed yes. Is that presumption absolute?
No, you can overcome it, but only if the claim limitation itself also recites sufficient structure to perform the function. If you spell out the structure right there in the claim, even with the word means, you might avoid 112F.
Right.
But usually, means for means 112F.
Okay, makes sense. What's the flip side? The second presumption.
The opposite. If the claim doesn't use means or step, then it's presumed not to invoke 112F.
Which covers most claim elements, probably.
Most, yeah.
Yeah.
They just use standard structural or action words, and they get interpreted based on their plain meaning.
But, and here's where it gets really interesting, I think. That second presumption, the no means no 112F one, isn't set in stone either, is it?
Ah, yes. This is crucial, and the Williamson case really hammered this home. Even without means, 112F can still apply.
How?
It applies if the term you use instead of means fails to provide any real definite structure. If it's just acting like a generic placeholder, a sort of nonce term for the function, then it can still trigger 112F.
Like a synonym for means that doesn't actually add any structural information.
Exactly. You're just swapping one vague word for another.
So how does an examiner figure that out? Is there a checklist?
There's a pretty standard three-prong analysis they use.
Okay, prong one.
Does the claim use means, step, or some other term that skilled people in the field would just see as a generic placeholder, not a real structure? Think words like module, unit, device.
Okay, placeholder check, prong 2.
Is that placeholder term modified by functional language, usually linked by words like for configured to so that it does X?
Describing what it does. Got it. And prong 3.
And this is the kicker. Is that placeholder term not modified by enough structure, material, or acts right there in the claim itself to actually perform the stated function?
So if you had all 3 placeholder word, functional language, no structure in the claim boom, you're likely under 112, even without saying means.
That's the test. It's all about whether the claim itself provides the structural identity.
Let's dig into that first prong more, the generic placeholders versus actual structural terms. This feels like where arguments could happen. What are examples of placeholders?
Well, the courts and the USPTO look at the spec, dictionaries, how the term's used in the field. Common ones found to be placeholders, unless given structure, are things like mechanism for, module for, device for, unit for, also component, element, member, apparatus, system for.
Module was the big one in Williamson, right?
Yeah, distributed learning control module. The court said module by itself didn't provide structure, it was just a box performing a function.
Okay, those sound pretty abstract. What about words that usually do imply structure and help you avoid 112F?
These are terms that people in the field recognize as having a generally understood structure, even if they also imply a function. Think everyday things: filter, brake, clamp, screwdriver.
Things you can picture.
Right. Or more technical ones like circuit, detent mechanism, digital detector, reciprocating member. Even if they do something specific, the name itself conveys structure to someone skilled in the art.
So the test is, does the word itself conjure up a class of structures, or is it just a label for a function?
That's a good way to put it. If the examiner thinks it's just a label, a placeholder, they have to say so in the office action.
And give the applicant a chance to argue back.
Exactly. You can argue the term does have structure, point to evidence, or you can amend the claim, add structure, or maybe even add means if you actually want the one-to interpretation and its corresponding scope.
Okay, clear communication is key. Now, let's shift to the other side of that quid pro quo, supporting these claims in the specification. If you do use a 112F language, what exactly needs to be written down?
This is where things often go wrong. If your claim invokes 112F, the specification must clearly disclose the corresponding structure, material, or acts that perform that claimed function. It's not optional.
And if you don't?
Then the claim fails. It's considered indefinite under 35 U.S.C. 112b. It doesn't clearly define what's protected because the functional language isn't anchored to any specific structure.
What's the standard for clearly disclose? How much detail?
Enough detail so that someone skilled in the relevant technology can read the specification and understand what specific structure you're pointing to as performing the function.
So just saying use known techniques isn't good enough?
Definitely not. Courts have shot that down. Vague statements don't cut it. And crucially, you can't just incorporate it by reference from another patent or article. The supporting structure needs to be in your specification.
What if it's something really basic, something everyone in the field would just know how to do? Does it still need to be spelled out?
That's a nuanced area. Sometimes structure can be implicitly disclosed if it's like blindingly obvious to a skilled person reading the spec. Maybe complex math implies a computer is doing it.
Okay.
But the main question isn't, could a skilled person figure out how to build something? That's enablement 112A. For 112F definiteness, the question is, did the specification itself disclose the structure? You have to point to it in the document.
Ah, that's a vital distinction. It's about disclosure, not enablement. You have to show the structure, not just rely on someone else figuring it out.
Yeah.
And you mentioned linking.
Yes, very important. The specification should clearly link or associate the structure you're describing with the function you're claiming. You need to make that connection explicit. This part here, this is the means for doing X.
Why is that link so critical?
Because the claim scope is limited to that disclosed structure and its equivalents. The link establishes exactly what structure defines the boundary of your functional claim element.
This sounds like it could get especially complicated with software or computer-implemented inventions. Are there special rules there?
Oh, absolutely. This is a huge focus area. For computer-implemented functions claimed using 112EFF, the specification has a very specific requirement. It must disclose the algorithm for performing the claimed function.
An algorithm? Why not just say a computer or a processor? Isn't that the structure?
Generally, no. A standard off-the-shelf computer or microprocessor isn't usually considered enough structure by itself for a specific function under 112F.
Why not?
Because the actual structure isn't just the chip. It's the chip programmed in a specific way to perform that function. It's the special purpose computer created by the software. So the algorithm is part of the required structural disclosure.
So the algorithm essentially defines the special purpose aspect.
That's the idea. It turns the general box into the specific machine that performs the claim steps.
Are there any exceptions? Times when just saying processor is okay?
Courts have said maybe in rare circumstances. If the function is incredibly basic and truly coextensive with what a processor just does, like fundamentally receiving data, storing data, maybe basic processing.
But anything more complex needs the algorithm.
Pretty much anything requiring specific logic or steps, special programming, you need to disclose the algorithm.
What does that look like in the patent? Do I need actual source code?
Thankfully, usually no. You don't need lines of code. The algorithm can be described in prose, step by step. It could be a flow chart. It could be a mathematical formula. Any way that clearly lays out the steps or logic so someone skilled can understand how the function is performed.
So clarity is key. What are the common mistakes people make here? Where do software-related 112F claims typically fail?
Big one. Just disclosing a general-purpose computer and saying software does it without the algorithm, that's a no-go.
Okay.
Another is using fancy names for software components, like calling something the access control manager, but not explaining the steps that manager takes. Just giving it a name isn't structure.
Need the how.
Need the how. And remember, if your means for element performs multiple functions, say function A, B, and C.
You need the algorithm or structure for all three.
For all three. Can't leave one out. And again, that enablement trap, you can't just say a skilled programmer could figure out the algorithm.
Right, because it's about disclosure, not whether someone could invent it.
Exactly. The algorithm itself is the structure that must be disclosed. If you fail here, the claim is indefinite under 112B, and you probably also lack written description support under 112A because you haven't described the specific invention properly.
Wow. So for software, using a 112F really forces you to lay out the operational details, the algorithm, in the specification.
It absolutely does. It's a trade-off demanding real detail in the disclosure.
Now, something you mentioned earlier, 112F applies to an element in a claim for a combination. What if someone tries to write a claim with only one element and describes it using means plus function? Like the whole invention is just means for doing the main thing.
The dreaded single means claim. That came up in the Henry Hyatt case. Because 112F interpretation applies to an element in a combination, a claim with only one single means element. Well, it doesn't fall under a 112F.
So it doesn't get that special interpretation rule, the one tying it to the disclosed structure.
Correct. And without that 112F limitation, the claim would theoretically cover every possible way to perform that function.
Which is usually way broader than what was actually invented or described.
Almost always, yes.
Yeah.
The specification might show one or two ways, but the claim, without a 112F, tries to cover all ways.
And what happens to a claim like that?
It typically gets rejected under 112A as not enabled. The specification simply doesn't teach how to make and use all those possible means the claim would cover.
So the takeaway is, don't draft single means claims. Make sure you're claiming a combination of elements.
Pretty much. Now, be careful. This is different from a claim to, say, a system where the system itself is described as performing multiple different functions.
How so?
Well, even if system is a generic placeholder, if you claim it performs function X and function Y and function Z, you're claiming a combination of functions performed by that system. Each function might need its own 112F analysis and support, but it's not a single means claim because you're describing multiple distinct operations within the claimed element.
Got it. So a single element performing multiple functions is okay and potentially subject to a 112F for each function, but a claim covering only one functional element overall is usually invalid.
That's a good summary. It's about the overall structure of the claim.
Okay. Navigating all this, the presumptions, the tests, the disclosure rules, especially for software, the single means trap, it really seems to require a clear back and forth between the patent applicant and the examiner. How does that clarity get maintained in the official record?
It's vital. When an examiner decides 112F applies, they really should state that clearly in the office action. And they should identify what structure in the specification they believe corresponds to the function.
So the applicant knows exactly how the claim is being read.
Right. It gives clear notice. Then, if the applicant disagrees, they have to respond specifically.
How?
They can argue, no, this term does have structure, point to evidence. Or they can amend the claim, add more structural detail, for instance. Or if they wanted 112F but didn't use means, they could amend to add it or clarify the placeholder status.
What if the claim language is just murky, ambiguous, hard to even apply the test?
That could lead to a different rejection indefiniteness under 112B, just based on the unclear wording itself.
Oh,
Gives the applicant a chance to clarify. And if the examiner does apply 112F, but literally cannot find any structure in the spec for the function.
that's a 112B rejection too, for indefiniteness.
Yes, classic indefiniteness, because the functional claim isn't anchored to any disclosed structure. Sometimes the examiner might ask for more information first, but ultimately, no structure means an indefinite claim. And even if structure is implicitly there, the USPTO can actually require the applicant to amend the specification to make that link between the structure and the claimed function explicit, just to make the record crystal clear for everyone later on.
Okay, so it's all driving towards a clear record showing what structure performs what function when 112 is in play, and when a patent is finally granted with 112 claims.
The examiner should ideally note that in the reasons for allowance, they'd confirm 112F was applied and point to the supporting structure, just to wrap it all up clearly.
Right, so let's try to boil this down. We've dived deep into 112F. It's this rule letting you claim something by function. But the big trade-off, the quid pro quo, is you must show the specific structure, material, or acts doing that function in your specification.
And your claim scope gets tied only to that disclosed structure plus its equivalents. Not all ways to do it.
Choosing claim words as critical means raises a flag, but so can generic placeholders like module or unit if there's no structure described in the claim itself.
And for software, that disclosed structure absolutely has to include the algorithm, the how.
Exactly. It really forces a balance between describing what your invention does and how it does it, especially for software. Precision in the claims, precision in the spec you need, both for these functional claims to hold up.
It's complex, no doubt, but fundamental for understanding patent scope.
It really underscores how much the specific legal language shapes the protection you get. Which makes me think that requirement for disclosing a specific algorithm for computer-implemented means plus function claims.
Yeah.
In software, things change so fast. Algorithms get updated, new approaches emerge constantly. If your patent scope is tied to the specific algorithm you disclosed back when you filed, how does that affect the patent's value over time? Does it make these software patents potentially weaker or maybe easier to design around as the technology just naturally moves on?
That is a really good question. It points to a potential tension between this legal requirement for specific disclosure and the reality of technological evolution, especially in fast-moving fields like software.
Definitely something for you to think about regarding the longevity and strength of software patents granted under this rule. That's all the time we have for this deep dive.